Welcome back, everybody, to the Law of Contracts. This is the final lesson where we're going to be covering the creation of contracts, and we're just going to talk about the requirements for promissory estoppel. So, the previous lesson introduced the doctrine of promissory estoppel and what it fundamentally meant and what it entailed. We noted that what promissory estoppel fundamentally is an example of an equitable doctrine whereby an individual cannot renege on a promise. They would be stopped from doing so. This lesson is going to talk in more detail about the things that are required to ensure that promissory estoppel can be applied. What is needed for promissory estoppel fundamentally? So last lesson, all we did really was take some time to talk about the case that illustrates promissory estoppel, the High Trees House case. This lesson is going to talk about what is actually needed to show promissory estoppel, or to have a successful claim for promissory estoppel. So as noted, it relates to the idea of one party in a contract waiving their rights to a certain thing, and then the other party in that contract acting on the basis that those rights have been waived and that this promise will be kept. In that circumstance, if the person who is waiving their rights then try to go against that and try to renege on that promise, then they will be stopped from doing so in the law of equity, fundamentally. It is a defence against parties being put in difficult positions, having acted on the basis that they had that a certain promise would be kept. So if you have an agreement with one person and another person, and one of these people says that we're going to waive our rights to this thing, and then you, as a result of that, act on the basis of the fact that you believe that those rights have been waived, and the person then comes in and says, well, actually, we're going to renege on that promise. We're not going to. I want to enforce my rights to do this thing. Well, then you've been put in a difficult position because you have now just acted on the basis of the fact that that right has been waived and that the person has promised that they would not enforce this right. If they then go on to enforce that right, then it is seen in equity that they should be stopped from doing so. Now, it can only ever be, the doctrine of promissory estoppel can only ever be a defense to this kind of action. The reason why is because equity must be a shield and not a sword, one of the most important equitable maxims here. Equity steps in to protect those who may have been treated inequitably, fundamentally. It is not used and wielded as a sword to essentially attack parties with. That's how equity works. So, what are required? What are the things that are required for for promissory estoppel to be applied? Well, the first thing that is needed is a clear and unequivocal promise. If we remember back to the previous lesson, to the case of Central London Property Trust versus High Trees House Limited, the owners of the block of flats made a very clear promise to the defendants. The clear promise was, we will not ask for the full rent of £2,500 a year because there had been a limited occupancy owing to the Second World War. Now, given that the lessees had acted on the basis of that promise, they had not charged so much rent, it'd be inequitable for this promise to then be reneged upon because it would put High Trees House Limited in a very difficult position, owing to the fact that they had acted on the basis of the fact that the promise would be kept and that their rights under the contract would continue to be waived. The next part is that the promise in question has to be a promise which waives the rights of one of the parties, but it also has to have an impact on the legal relationship between the parties. So what does this mean? Well, if we go back to the previous lesson, what it had done is it had altered the legal relationship between the claimants and defendants, because the legal relationship was for a contract that existed between these two individuals about a certain price of rent which was going to be owed. That legal relationship then changed as a result of the fact that the claimants agreed to and promised to waive their rights by reducing the rent. So there has to be a waiving of rights, and this waiving of rights has to change the legal relationship between the parties. The next point is that the promise in question to waive the rights must be one that the other party relies upon and that acts upon. So again, if we remember back to the previous lesson, what had happened here is that the other party, as a result of the fact that they had been promised that their rights would be waived, altered their behavior in relation to the promise in such a way that it would put them in a difficult position if the promise was then to be reneged upon, if they went and tried to enforce their rights. And then this is the final point. It can only ever be a defense. And so it is only in circumstances where the promise is then reneged upon and the party then tries to claim the full rights which they had originally waived that the equitable doctrine of estoppel comes in, where they can be stopped from doing so. So those are the requirements for promissory estoppel. There has to be, first, a clear and unequivocal promise. That promise is got to be a promise which waives the rights of one of the parties and has an impact on the legal relationship. The other party then has to rely upon this promise and change their behavior in accordance with the fact that this promise has been made. And if this promise was then reneged upon, would put them in a difficult position. And then finally, it can only ever be used as a defense, owing to the fact that equity is a shield, not a sword. Finally then, let's illustrate this point in the case of Combe & Combe from 1951. This case, a husband had made an agreement to pay his wife a certain amount of money each year. This was a total of £100 per annum each year, which in 1951 was actually quite a lot of money. When he then refused to pay at one point, his wife then sued. The claim would fail completely owing to a lack of consideration. But it was also noted, and it was also held, that the doctrine of promissory estoppel could also not be relied upon in this case, given that the doctrine is only ever a defense and not a cause of action. So if they would have relied on the doctrine of promissory estoppel in this case, it would have been in an offensive manner. It would have been in a way that would have been used to cause an action, not ever to defend against an action. And so, in quoting this point here, seeing that the principle never stands alone as giving a cause of action in itself, it can never do away with the necessity of consideration when that is an essential part of the cause of action. So the cause of action would have been the stopping of the husband from paying the money. From not paying the money, should I say, from refusing to pay the money, to renege on that promise. That would have been a case brought by the wife. So they would have brought a case on the basis of promissory estoppel, which would have meant that promissory estoppel would have been used as a sword rather than a shield, therefore cannot be relied upon, given that it can only ever be a defense.